responsibilities that accompany advances in reproductive medicine. So, joining us today are very eminent speakers and chairpersons, and we are privileged to have such distinguished experts with us. I'm confident that their insights and experience will make this session both engaging and enriching. I warmly thank each and every one of you for your participation and contributing to what promises to be a highly informative and meaningful discussion. I would like to welcome our chairpersons for today. Dr. Shruti, can you display their CV, please? I'd like to welcome Dr. Rajpriya Ayappan, who's the South Zone Coordinator of IFS. She's also the Managing Director of Home Fertility Center and Srinivas Priya Hospital in Chennai. Madam has held several positions before. She has been the IFS Past Secretary of Tamil Nadu, the ex-committee member of OXI, and Sexual Health Committee member of OXI, Women's Wing Secretary, and she has also conducted the ICOG FOXI RM course, reproductive medicine course as a head in Chennai. She is also a MRCOG Part 3 examiner. Madam, we are very grateful to have you amidst us today. Thank you for joining us.
Thanks for that nice introduction, Dr. Mangala.
I'd also like to invite Dr. Rekha Rajendra Kumar, who is our Vice President FOXI South Zone. Can I have a CV, please? So Dr. Rekha has a very big CV and she needs no introduction. She is very popular among us. Nevertheless, she has been the president of Bangalore Society of OB/GYN. She's a chairperson of FOXI Medical Disorders and Pregnancy Committee. And she's been the organizing chairperson of very good conferences like FemPower and MDIP. She has been invited faculty in a large number of conferences and has been awarded with so many awards. I think we'll have to count what she hasn't received rather than received. Thank you, Dr. Rekha, for joining us today.
Thank you, Mangala, for inviting me. Thanks. Thank you.
So I'd also like to introduce our guest, Mr. Dattatreya. Please put his CV on.
My disconnect for a second and get.
Shruti, his CV? So Advocate Dattatreya is an advocate with the Karnataka Bar Council. Sir has very generously accepted to be in the panel today, in spite of giving him very short notice. He's been practicing in the High Court and the trial courts at Bangalore. He specializes in criminal law and healthcare law. Welcome, sir. I would like to then now introduce our moderators of the panel, Dr. Divyashri. Please put her CV. Madam, Dr. Rajpriya ma'am, meantime, can you please say a few words?
Yeah, thanks. I am really happy that IFS Karnataka has taken the step forward to bring this medico-legal webinar today, because I guess clinical acumen, constantly we are having webinars, but to have a webinar where focusing on medico-legal, real-time clinical case challenges, telemedicine, and you bringing out the newer concepts, I think it's going to be very useful for doctors who need to know a little bit of the law in their practice. So go ahead and introduce the moderators.
Dr. Rekha, please say a few words and you can introduce the moderators.
Yeah. Thank you, Dr. Rajapriya, for being the co-chair for me. Dr. Mangala, again, congratulations for taking a leading role and conducting such a wonderful webinar here. As Dr. Rajapriya said, it is really unique, and I'm sure many of us will be benefited by such novel and a unique kind of webinar with that kind of principle. It's my privilege to introduce Dr. Divyashri, who is the moderator for this panel. Dr. Divyashri is going to conduct a panel. 1 minute. She's going to conduct a panel on real-life medico-legal cases in ART, lessons learned. She's a medical director at Genia Fertility Center, Bangalore. She's a member of the State Board for ART and Surrogacy, Health and Family Welfare, Government of Karnataka, recipient of certain awards, and has fellowship in reproductive medicine through national NBE examinations and medical law and ethics also from National Law School. Dr. Divyashri, welcome to the podium. Please take it forward. Thank you.
Dr. Shilpa also. Dr. Shilpa Reddy is also our moderator, the co-moderator on
I
this
have
panel.
Yeah, Dr. Shilpa is a very vibrant young ART specialist. I have met her in conferences. She's a consultant in infertility and reproductive medicine at Milan, Bangalore. She has certain awards and accolades of very high quality. Joint Treasurer of IFS Karnataka chapter at present, best outgoing student in UG, has received gold medal in many subjects and authored a chapter on lifestyle factors that influence fertility. That's very interesting, Dr. Shilpa. She's faculty at Milan at present, and her interest is in reproductive immunology, RIF, and poor responders. Over to both of you, Dr. Shilpa and Dr. Divya, to conduct this panel, and wish you all the best.
Thank you so much, ma'am, for the kind introduction.
You may invite the panelists and proceed.
So good evening, everyone. We'll be very privileged to be having an esteemed panel of experts who will be sharing their perspectives, experiences, and practical insights into navigating complexities of medico-legal issues. So here in the panel today, from the clinicians' side, we have Dr. Sumana Gurunath, Dr. Ashwini, Dr. Sneha J, Dr. Jyoti Patel, and from the embryology side, we have Dr. Ravi Nirvani. And as a legal expert, we have Mr. Dattatreya. Shruti, can you please put up the CV slides? Okay. Dr. Shruti? Okay, I think she's muted. So just to have a quick introduction of our panelists, Dr. Sumna Gurnath, she's a very senior consultant in fertility and reproductive medicine from Cloud9 Hospital, Malleshwaram. She is the associate editor, Journal of Human Reproductive Sciences, and she has had over more than 20 publications to her credit. Welcome you, ma'am. Next, we have Dr. Ashwini. Dr. Ashwini is a consultant and director of Aspire Fertility Center. She's had many achievements like Dr. Tamaskar Research Prize Award for the Best Research, ISAR Rising Star Award, and many other accolades to her credit. Next, we invite Dr. Sneha J. She is a consultant and medical director at Orchids Health.
Hello.
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 Yeah.
Now, ma'am. Sorry. I'm unmuted, ma'am.
Okay. That's fine.
Dr. Sneha J, again a senior consultant and medical director at Orchids Health. She has done her observership at Assisted Reproductive Unit at Queensland University. Ma'am is very dynamic. We've seen many of her reels. She is a EC member of Karnataka chapter of IFS since 2024. She has many awards for her. She has taken many awards with her. The next we have Dattatreya lawyer, we have, he's been with us since a long time, very dynamic, sir. He's always come for our help. He has very practical way of telling cases to us. We look forward to sir's experience in this seminar, practical experience. Next.
Thank you.
We have Dr. Ravi Nirvani. He is a PhD in reproductive biology, lab director and chief embryologist, Altus Hospital and Cambridge Hospital, Bangalore. He is the first to achieve a day 3 embryo biopsy PGT baby delivered in 2012. Welcome, sir. Next.
Thank you, madam.
Dr. Sumana Gurunath, as we can see, a very good academic background, and ma'am is presently a consultant, infertility and reproductive medicine consultant at Cloud9 Hospital, Malleshwaram. She has lots of publications to herself, and as we know from all her fellows, ma'am is like a walking, talking of all the recent guidelines and papers. Ma'am is very up to date. Next. Dr. Ashwini GB, ma'am is a director, teacher and a chief embryologist, fertility specialist at Aspire Fertility Center. This is a very different combination. We can see ma'am is into embryology as well as doing fertility. She has a very good academic background. Lot of papers to her, lot of papers which she has done. Lot of achievements. She's awarded the many Foxy Awards, many publications in her name. Next. Ma'am, can we start the hello?
Yes, I'll start, Shruti. Are the slides visible? Can you just confirm?
Yes, ma'am. We can see, ma'am.
Okay. Thank you. So here we are going to be having discussion of about 4 or 5 real cases that we have encountered in clinical practice. So the aim is basically to identify ethical, legal, and clinical challenges, get opinion from the clinicians, as well as from a legal expert as to how they would have navigated the case or as to how they would go about it. We just have a short video clip of an OPD case scenario.
ನಮಸ್ತೆ ಹೇಳಿಮ್ಮ ನನ್ನ ಹೆಸರು ಸುವರ್ಣ ಆಲ್ರೆಡಿ ಬೇಬಿ ಆಪರೇಷನ್ ಆಗಿದೆ ಏನಾದ್ರೂ ಮಾಡಿ ಹೆಲ್ಪ್ ಮಾಡಿ
ಅರ್ಥ ಆಗತ್ತಮ್ಮ ಆದ್ರೆ ಲಾ ಪ್ರಕಾರ ಏನ್ ಗೊತ್ತಾ 50 ವಯಸ್ಸು ಮೀರಿದ್ಮೇಲೆ ಈ ಸರೋಗೆಸಿ ಆಗ್ಲಿ IVF ಟ್ರೀಟ್ಮೆಂಟ್ ಆಗ್ಲಿ ತುಂಬಾ ಕಷ್ಟ ಆಗತ್ತೆ. ನಿಮ್ಮ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಪ್ರಕಾರ 50 ವಯಸ್ಸು ಆಲ್ರೆಡಿ ಮೀರೋಗಿದೆ. ಸೊ ಈಗ ಲಾ ಪ್ರಕಾರ ಏನು ಮಾಡಕ್ ಬರಲ್ಲ ಅಮ್ಮ ಇವಾಗ.
ಮೇಡಮ್ ಏನಾದ್ರೂ ಆಗ್ಲಿ ಪರವಾಗಿಲ್ಲ ಮೇಡಮ್, ಆಧಾರ್ ಕಾರ್ಡ್ ನಾವು ಚೇಂಜ್ ಮಾಡಿಸ್ತೀನಿ.
ಅದ್ ಹೇಗ್ ಸರ್ ಆಧಾರ್ ಕಾರ್ಡ್?
ಇಲ್ಲ ಆಗಲ್ಲ ಮೇಡಮ್, ನಾ ಡೇಟ್ ಎಲ್ಲ ಚೇಂಜ್ ಮಾಡಿಸ್ತೀನಿ, ಮಾಡಿ ಮೇಡಮ್, ಏನಾದ್ರೂ ಪರವಾಗಿಲ್ಲ.
ಆಧಾರ್ ಕಾರ್ಡ್ ಅಲ್ಲಿ ವಯಸ್ಸಿನ 50ರ ಕೆಳಗೆ ಅಂತ ತೋರಿಸ್ತೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಸರ್ ಆಧಾರ್ ಕಾರ್ಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಹೆಂಗ್ ಚೇಂಜ್ ಮಾಡಕ್?
ಏನಾದ್ರೂ ಇದ್ ಮಾಡ್ತೀನಿ ಮೇಡಮ್, ನೀವು ಮಾಡ್ಲೇಬೇಕು ಮೇಡಮ್, ಪ್ಲೀಸ್ ಮೇಡಮ್.
ನಮಸ್ತೆ.
So the case summary is that we have an elderly couple who is there. The age cutoff limit has been crossed and the husband is openly proposing to falsify Aadhaar card documents to bypass age restriction and thereby be eligible to undergo the treatment. So the key dilemmas that we basically have is that, yes, intent to falsify government ID documents. What is the clinician's responsibility when patient proposes doing such tasks? Touch a bit upon age restrictions under Indian surrogacy and ART regulation. So the question for the panelists would be that, yes, if at all there is such a scenario that is encountered, how is it that the clinician is supposed to respond? Can we start with Dr. Sumana, ma'am?
Yeah, so I think we should be very categorical in stating that the law forbids us to do any IVF treatment for someone over 50 years. So here we are looking at 2 aspects. So one is the couple is liable. So if they falsify documents for purposes of Aadhaar, they are liable to be imprisoned for 3 years. And we as clinical clinicians, now if at all we go against the law, then we are also liable to be punished. So for first contravention, it is fine. and for the second one, it is imprisonment with a fine. So I think we should abide by the law of the land and stick. And if at all they do really want, then they should take a legal opinion and see if the court allows it.
Right, ma'am. So having said that, yes, we are all aware that Aadhaar card forgery is a punishable offense. So in case the patient shows or expresses interest towards that, so are these interactions supposed to be formally documented to safeguard ourselves?
I think we should educate the couple, and if at all they are insistent on it, and I think it is very important nowadays also to authenticate any Aadhaar that comes across to us. So we should go to the Aadhaar verification center and see whether whatever Aadhaar is offered by the patient is actually authentic or not. Incidentally, we had a patient who had 4 Aadhaar cards, and when we authenticated, we found the age was anywhere between 48 to 52. And when we authenticated it, we found out that her actual age was 52. So I think it is very important to document these things and then to safeguard ourselves.
Right. Ashwini, ma'am, the next question is to you. Having understood that, yes, surrogate programs, donor egg programs are going on. So is it the clinic's responsibility to be basically authenticating the validity of the Aadhaar card?
1 second. Can you hear Dr. Shilpa?
Yes, ma'am.
Hello?
Yes, ma'am. Yes, ma'am. It's audible. You can go on.
We can hear you.
That's what actually in continuation with Dr. Sumana's question, that is it mandatory to authenticate everything? Many a times we get falsified documents of even voter ID, all these things. And how feasible it is as clinicians, how do we manage when because any government ID proof is okay. Many a times we have seen there is discrepancy, but some give voter ID in which they would have falsified the document. So even lawyer is here. How are we liable in future? Later on it becomes a case, and then it is shown that probably they are underage or above the age cutoff. So how does doctors become liable? And as clinicians, how are we going to safeguard ourselves? Can anybody take this question, please?
See, ma'am, replying to your question, now there is a modus to authenticate the Aadhaar card. We cannot plead ignorance and say that there was no modus for us. There, we can go to the UIDA website, input the login details, and verify it. Other documents, we as a private establishment, the onus is not upon us. But however, if we get to know that a patient is falsifying, forging any of the document, and we allow them to do it within our records, then we are a part of the conspiracy, of the criminal conspiracy. You can't plead ignorant there. Now, you think, okay, if there is any sort of a doubt insofar as a particular document is concerned, you can ask the patient to always make another additional affidavit stating that it is an original document.
So that is in the event that we have a doubt about the authenticity.
Have a doubt. Only when you have a doubt.
So what if we are not aware, go ahead for the treatment at a later point of time, realize that yes, that's false?
This has to be decided on a case-to-case scenario. That's why I usually advise all people to go with one particular notary or one particular advocate, because if you allow the patients or the agents or the people who are in between to do it, how will a particular person come and depose on behalf of? How will a particular person come and depose before an authority or a court of law? So it is always important that we have a structure where we have trustworthy outsourced people who do the work, who are there for our calls, who come back if at all any document is in doubt. We get an affidavit, then we get to know it is false. At least we have someone to come and depose before a court of law or before any authority.
So then for that matters, I think every registration that is done, there needs to be an affidavit.
No, it is not required, doctor. Most of the cases, we always get additional documents. To collect Aadhaar, check the passport, somewhere who's handling the initial front office, who's counseling all the people, must also read the patient of how they are they fabricating, is there something doubtful, and then take a call on a case-to-case basis. We can always collect additional documents. Get all the documents self-attested. If it is through a donor who is uneducated, it might sound a little crude. Make sure you get the thumb impression on that.
Practically, doctors, do you people actually do all these things? Like we take Aadhaar card, but there will be a lot of resistance from patients. Why are you asking our personal identity? This is everyday thing for us. And I want other doctors to opine on this. What difficulties are you facing when you ask for identity? What difficulties are you facing, and how are you tackling? So that there is no hard and fast rule that okay, this is how we are going to do. We just want to understand and share the experiences that how you are going to tackle and what you people are doing. Because
Madam, can I get it?
yes, sir, please.
What sir has mentioned about the authentication of the Aadhaar card, like suddenly you can go ahead with the UHID verify, but the thing is like the OTP will go to the respective phone number which is attached to that Aadhaar card. Otherwise, it's a matter of 5 minutes to just load down once you place the Aadhaar number into it. Definitely we will come to know whether it's an original or the document is forged or something like that. So, but only thing if you have a counselor proper, you can really uh, take the complete authority on that, and she can definitely go ahead with all the details, other authentication, and then she can give a consent. Once the counselor gives the consent, I think you can go ahead with the treatment protocol.
Dr. Sneha, Dr. Ashwini, you have to say anything on this?
Aadhaar card, can all of us actually access that UHID just with the Aadhaar number?
Yes, madam.
Yes.
The OTP comes to the person who's holding the phone. We can, and if they give the input, what Aadhaar card we have in hand must correlate to what is on the screen. That is the test.
Okay. Some people have more than one Aadhaar card, no, 2, 3 Aadhaar cards. So whatever card they have given to us, we need to authenticate only that one.
Please.
Yes. So sometimes say I get another Aadhaar card, and I've seen people coming back after 1 or 2 months with another Aadhaar card with a changed age.
That happens usually, ma'am. More so with the donors and the surrogates.
Verified Aadhaar card also, sir.
2-year-old, 51, 52, those who've just touched that age group, they also come back like that, sir?
Ma'am, that is difficult, ma'am, because in whatever limited exposure I have to dealing with patients for surrogacy and the ART affidavit work, usually there is no trouble with the intending couple, most of them. It is always your donor documents which you see, they will go to one center, they will change some sort of a face ID, come here, come to another center. That is when the problem is. We as a clinic, we have both people who we are treating. We are giving treatment to a donor, we have to giving treatment to an intending couple. So somewhere we have to audit what we are doing, how we are going on a case-to-case basis, take additional video consents more than the written consents if required.
Okay. Sir, and regarding the marriage certificate?
Marriage certificate, not many people have, but it is now become a very easy procedure to get a marriage certificate, especially in not only urban Bangalore, most urban places of other districts also. It has become online, it is got easy. If the couple are, the patients are fine, they are reasonable, suggest them to get a marriage certificate. If that is not there, check. Usually rural side people have ration cards where both the names are there. Along with that, obtain a marriage photograph, especially with people around, and ask them to give you a marriage affidavit if required.
Okay. Okay, sir.
Sir, now with the pending surrogacy renewal license, are we allowed to proceed?
I think the latest notification has been issued now. that for renewal of licenses. I will post that to you, ma'am, once after the webinar.
Right, sir.
I think more or less all of us are on the same opinion that it is very important to identify that. I mean, to have an important identity, to check identity, it is still doctor's responsibility, even the proof of marriage. I think all of us are on the same page, and definitely falsifying the documents we should not encourage. Because this point now we are like almost 4 years down the lane past the act, but initially even doctors had this resistance, but now I think we are all of the opinion that this is a very important point to have the identity, age proof, and marriage proof. I think we can move on to the next.
With the small thing, if I can interject, I'm sorry. With the ART Regulation Act, the Act clearly says below 50. That means 49 years and 11 months for a lady, and 54 years, 11 months for a male. The Surrogacy Regulation Act, however, says the entire 50th year and the entire 55th year. That is 55 years, 11 months, and 50 years, 11 months. Up to then, it is covered, and we have had a latest judgment from the Chennai High Court as well, clearing these points.
Okay, sir.
This is 50 below, that is within the 50. There is a distinction between the age category of 1 year between the Surrogacy Regulation Act and the ART Regulation Act.
Yeah.
Okay, sir. Fine. So with that, I think we'll move on to the next case scenario.
Hi, doctor. I'm Priya. My husband, Mr. Aditya, has frozen his sperms here in the year of 2016 before undergoing his cancer treatment, but now he's no more. So I want to use his sperm to undergo IVF, and I want to become a mother. So,
Hi, Priya. I'm very sorry for your loss. Let me go through the records and see what it is. Okay, I can see the sperms being frozen, but I don't see any consent office that is stating that the sperms can be used after his death. So legally, I cannot be using the sperms for IVF treatment.
how is it possible? If he's frozen his sperm, he's my husband, I'm his wife. Definitely, he is frozen this for the future use only. How could you say that is because one signature we cannot go for IVF or I cannot become a mother?
I understand your emotions totally. I understand your urge to become mother, but legally, if I have to see, there is no consent to use his sperms after his death, and without the consent, I cannot go ahead. I'm really sorry.
So here is a widow who is basically seeking IVF treatment, who wants to use her deceased husband's cryopreserved sperm. But however, when the documents are checked, there is no formal consent in place that the husband has given. So in such scenarios, how do we proceed? So in older cryopreservation cases, say I think dated almost 8-10 years back, where documentation is not complete, how is it that the clinics are supposed to proceed? Dr. Ashwini, can you comment on this?
I think Dr. Ashwini is not unmuted.
She's not joined, right?
Or she's not unmuted. Dr. Joseph Patil can take this question.
Yeah. Thank you, Ray. See, I think in last 10 years back, we all had faced this issue about this older cryopreservation cases, wherein there was no clarity about what to do of the sample after death and who should take the ownership of the gametes and how to dispose the sample after death, and whether do we have to go for a withdrawal of consent, and what are the rights of the surviving spouse. We never had any clarity, and I don't think so we have clarity right now. So from my side, I feel yes, we should always say like no consent is equal to no posthumous use. And when we don't have clarity on all these things, we should document each and everything saying the spouse is no more and the clinic cannot release the sample and cannot proceed with IVF. And we can seek legal advice and counsel the widow separately and more compassionately.
Rightly said, Dr. Jyoti Patil. Do we have any other doctors commenting on this?
I just wanted to know, Dr. Divya and Dr. Mangla here. So I just wanted to, we can advise the spouse, the surviving spouse, to get from a court of law. Is that possible? And then, can we suggest such a thing?
That is what we have to ask our lawyer here. What we have to do in this kind of a situation, because these are all real case scenarios where explicitly the consent was not given. Post death or posthumous, it can be used. What do you say, sir?
I was somehow researching on this point a couple of months back, like how a widowed wife would inherit or succeed to a particular removable property once she succeed even by way of a gamete of her husband. That's a larger question to be answered. But however, if the clinicians feel that let us be safe, let us not get into this mess because you are the people, it is easy for me to advise sitting back channel. It is you are facing the front end of the patient. You can always suggest them to file a writ petition before the High Court and get a clear court order. And you can also issue a letter or a thing to them that explaining the present juncture of what has happened and tell them to get a required court order.
But sir, just 1 minute, sir. Sir, in your experience, sir, usually what happens, sir, when they apply for this thing, like they want to use the spouse sperm and undergo an IVF. So after
Unless
the death of the
explicitly,
husband.
sorry, doctor. Unless explicitly stated by the patient when he was alive that his semen must not be used even by his direct first line legal heir, then she will definitely, how she will succeed in a suit if it has to come to get a removable property or some fixed deposits, she will also get the gamete.
And will the clinic get a will the clinic get a copy or any documentation from the court?
Definitely,
which says
yes.
no, sir, which says that like you cannot go ahead with an IVF and you can discard the sample. Do we usually get something like this, sir?
You have to seek that relief if you have to do that, because now they would have approached the court with a certain prayer. Now, if you want to discard or do something like that, then you have to approach the court, or there must be general guidelines or applicable rules, and the rules has to be amended. Now they say for embryos, after 10 years, it can be discarded or used for research purposes.
Are there any such pilot cases which have happened before as an example for us?
There was one matter which happened wherein the wife wanted to use the semen of the husband. The clinic did not allow it. Then she got an endorsement from the clinic stating that they cannot allow because of the position of law. Then the High Court of Karnataka intervened and said that the wife must be allowed to use that gamete. That order was served, and I don't know what happened further after, whether the treatment took place, or I'm not aware of further facts.
And what about the position of the parents? Are they in a position to claim, like going to the court and all that?
Parents, it is a little difficult, especially with gametes, I feel, because then they can use it to whoever, or convince some sort of a lady not coming from an affluent background to get that particular semen as a donor semen program to do any ART technique. I don't think parents, that's a difficult proposition unless it is explicitly stated, or even if it is stated, whether the clinic must allow it, it must not allow it unless there is an explicit court order, madam.
Sir, actually, there is one consent in the ART Act, which basically, when you're taking consent from a minor.
Yes.
So that basically says, yes, do you want to make the gametes perish after your death or hand it over to your legal guardian, bar parents? So what does that actually mean? So do the parents have the right to...
That becomes a social conflict, and it will become nuisance value for all people running establishments, because you don't know where they will use it, where they will take it. So even if it is there available in the consent, for our safeguard, it is better there's a court order, then we will dispose it however the court says upon the direction of the court.
Sir, and there's something called as implied intent also, no, sir, wherein, yes, for the purpose...
But Highest legislated branch of medicine, all of you practice obstetrics and gynecology, MTP Act, PNDT, ART, surrogacy with so much of law. It is sometimes difficult to handle these sporadic cases. They must not become nonsense value to you.
So do the codes go by this intent, or the code goes by the paper value of the consent at the end of the day?
Difficult to interpret that. It depends on a case-to-case basis. To give a straight-jacket thing is slightly difficult.
And can the clinic become liable at any point of time for having not taken a complete proper consent back, sir?
Now, whatever consents are available according to the Act, we can take it. If we foresee any other gaps futuristically or some other scenarios, it is better to get a detailed affidavit, including what is frozen, how much is frozen, everything. Difficult, doc. We have to assess a case-to-case basis of what documentation we want, how we fill the gaps, what we do.
So summary is to save your skin, get the order from the court and proceed accordingly.
Please.
We also have a freezing consent form, no, where it says, in case of death, I can either donate it to my wife or donate it to my husband. So usually we see people ticking that. So what is the
Wife or
implication?
husband is still okay, ma'am, because it is a genetic property. If at all they wanted to start the family together, but now a minor son's death, do you hand that semen sample to a aged couple who are in their 70s or 60s? What will they do with that gamete? Or you can hand it over to a deceased husband who's 30 and the wife is 27 or 28. Because how they use the gamete, because it is always a matter of procreation with your subject.
Sir, just wanted to know about this. In case of the patient, like the deceased husband, wife, he wanted to take that sample back to them. So, how to go ahead, sir, in that condition? If they wanted to go ahead, they wanted
Check
to
the
take the sample
consent,
back.
sir. Check the consents. Check the structure of her family, the financial capacity of that lady, physical, emotional, mental health. Then you can take a call, sir.
Okay, okay. Should we take her family witness for that also? Like
You
we are
can take
handing
family witness, because what the end of the regulation is, it is the paramount interest of the child or children to be born. That is what is to be born in our mind. That is when the problem will start, if the child is ignored or not given proper care, and the child was conceived through an ART technique.
Suppose if sir, if it to take the sample back and store somewhere in there, so for an AIT bank or somewhere, yeah, and she can go ahead with other center to take treatment. Then my sample has been frozen in the AIT bank, okay, and from there she can take the sample and go ahead with the procedure. Or...
That is the problem with whole shifting of these gametes. Sir, they will pick up oocytes or semen from one center, take it to another center. You don't know what that center will do, whether it's gamete
No,
of...
sir, sorry, oocyte picking it, no.
No. Generally, I'm talking about gamete, sir. What have confusion with what is happening is, then the embryos will be made somewhere. Sir, I don't know. Just repeat your question if I'm talking out of context.
Sir, like if the patient wife, she takes frozen samples of her husband and she will store somewhere either in an ex IVF center or an AIT bank, and she will approach another IVF center. She will, and my husband's sample is frozen so and so in AIT bank or in especially in AIT bank. And IVF center, she wanted to go ahead with that sample for the IVF treatment. After once she is stimulated and go for an IVF, she can take a sample from the AIT bank and can go ahead with the procedure. Is it the right way? In case.
Sir, whatever your medical protocols which have to be followed is allowed. Now, I think there is somewhere the question of known donors. No, does it fall under that category? Because I could not hear you clearly.
It's not known to the husband.
There is some sort of background.
Sir, Dr. Ravi Nirvani, I think frozen sample from a deceased deceased husband taking to ART bank is out of question. But here the thing is whether it can be used in that particular clinic or not, or to shift to other clinic is something that has to be sought for. For that, I think prior consents have to be very important. But if at all it is even before the law, then court order is mandatory, is what I have understood, and we will,
Yes.
probably, finalize on this, and we can, if there are no further doubts on this, because we have to cover so many claims. That is why. Dr. Shilpa?
For clarity, because we have a separate consent for
Dr. Shilpa?
Ma'am, is it audible, ma'am?
Yeah, it's audible now.
And there's separate consent form for posthumous use of gametes, where there is a prior consent to be taken for posthumous surgical sperm retrieval also. Okay. So now we are going ahead with the third case scenario.
Dr. Shilpa?
Yes, ma'am.
Can you just go to the previous consent form? Just a minute. Yeah, so who is that we? Husband and wife?
Husband and wife, this is the consent given by the husband.
Yeah, because it says we, so I wanted to know who.
The husband and the wife, and this is a prior consent that is taken that in the event of the husband's death, the clinic is okay or allowed to be basically doing a surgical sperm retrieval and taking sperms out.
Signed by the couple before his death, the consent given.
Yeah, but this is a very hypothetical kind of situation. Like if the husband is very
I have realized it. I wasn't aware that there was a consent in place. So probably applicable to someone who has been through a
deathbed kind of a thing.
So because this is not something that we put across to everybody before their.
Yeah, it is kind of weird. That's why, yeah.
Okay. So we'll go ahead with the third case scenario.
Hi, Clara. Come. Hi, doctor. Yeah. How are you? I'm good. So just wanted to discuss with you. As you know, your husband was diagnosed with azoospermia, and so we went ahead with the micro T-cell procedure. But unfortunately, we were not able to retrieve any sperms. Okay, so I think I would like to discuss with you the further options. So we're considering going for donor sperm? Yeah, we had a discussion last night and we are okay with going with donor sperm, doctor. Okay, so I can guide you regarding how to procure the donor sperm through the ART bank. Doctor, but the thing is, I have an ex-boyfriend who is actually fit and fine. So can we ask him to go to the ART bank and give the sperm, and can we use his sperm for the procedure? See, someone known to you that would raise some serious ethical and legal concerns, it would be preferable to go. I get it, but I would prefer somebody whom I know than going for some anonymous donor from the bank. I think this should be fine that I can ask him to give the sperm.
So this is again one common scenario that I'm sure most of us would have encountered. So how is it that each of you just navigate through the situation? Do you just tell them that yes, donor anonymity has to be maintained, or are you flexible in your practice to make the patient choose their own sperm donor? Can we have an opinion from each one of you, starting with Sumana, ma'am?
I think the law clearly states that the onus on sourcing, screening, storing, and supplying the donor sperm lies with the ART bank. So, though it does not explicitly state that it approves known or unknown donation, I think it is implied that known donation should not be encouraged. And I think we have to procure anonymous samples from the ART bank, and that's what I do.
Okay, ma'am. Jyoti, ma'am, any difference of opinion?
Yeah, no, I completely agree with Dr. Sumana. See, we cannot take a sperm from a friend or a relative or a colleague or an ex-boyfriend or any known individual, because it is not accepted by the ART law. And we all abide by the ART law, so it always has to be an anonymous donation. And whenever, in case if the wife is asking about a known donor,
it's always better to document the thing that a known donor request has been raised by the spouse, but the clinic has not agreed for it, and we are approaching the ART bank for identifying a suitable donor.
Some of them, I've just heard a few people who have, like when they come across cases like this, they have routed the donor sperm through the bank. So like they say you go donate in that bank and they get the sperm sample back from the bank. Is that okay? I mean, legally should be fine, right? I have not done it, but I've heard people go through that.
There is
Madam,
no
what I feel is like if in such cases, the sample has to be quarantined at least for a 6 months, then it has to be released.
Yes, sir.
So even if the quarantine period is completed, are we okay to take samples from known donors, sir? Because the law does not mention anything about anonymity. So does that mean we are okay to take, or the law is just silent about it?
Legally, there is nothing that it has to be a known donor or an anonymous donor. Known donor, it will become always a sort of a confusion in the clinic because it is better to avoid known donors. If the couple still insists they have to go to the bank, it has to be a complete 6 month, whatever medical protocol quarantine period. Then the semen supplied and clearly mentioned in a detailed affidavit stating who the donor is and take consents of both the husband and wife. If otherwise, it is better to avoid known donors, wherein only one of the patient knows the details.
Sir, even no donor, if they are quarantined in an AIT bank will not disclose anything. It has to give through only their registered IDs will be there. Na? They have got some ID number which you have given for the donors. So
See,
they
that
have to
particular
provide, all the details has to be provided according to that only.
No, that particular video they showed of that boyfriend semen being given. And now it is better you tell the husband that so and so we are procuring semen. He is going to the bank, give the thing, and later we are going to process it and use that semen for the procedure.
So in the is there something that is going to be mentioned stating that it is a known donor?
Yes. State it is a known donor by the name doctor and get a detailed affidavit from both the couple that they don't have any issues. Then we avoid trouble as clinics.
So summary is anonymity is not strictly there either for sperm or the egg donor, but to keep yourself safe, have all this in the document as well as route them through the ART bank.
Please.
Very well said. Because it is not just about the sperm donor, it is about the egg donors also. Many times, people also want to get egg donors from a known donor. Probably it is something like emotional, or it could be something to do with financial. Like how surrogacy is altruistic, where there is no financial things involved. The same way, even they want to get a donor who's a sister or someone who is, and but it is definitely important to route through the ART bank. And especially in such cases, as lawyer rightly said, it's better to inform the husband, because later on you should not get into trouble. But now we have to be very aware that legally anonymity is not mandate.
So can the identity be revealed to the offspring at a later point of time when they insist? Or is that to the parents?
It can be revealed. It is again the structure of each how your upbringing.
Okay.
It's a moral, ethical, slightly social issue.
Okay. Anything else? We'll move on to the next one, ma'am.
Yeah, we can move on to the next one. And here, in case of known donors, again, as doctors, we have to do ethical and even scientific decisions also. I had one patient who's like, they want to get the egg donor, but it is from the sister of husband. So that's definitely not applicable, right? So just because it is a known donor is okay, but we also have to have some kind of ethics and science. So these things is something that we have to keep in mind. Okay, yeah, next question, please.
ಹಲೋ ಸರ್ ನಮಸ್ತೆ ಕಾಲಿಂಗ್ ಫ್ರಮ್ ಮಿಲನ್ ಮಿಲನ್ ಅಂತ ಕಾಲ್ ಮಾಡ್ತಿದ್ದೀವಿ ಸರ್ ಆರಾಮಿದ್ದೀರಾ ಓಕೆ ಸರ್, ಈ ಕಾಲ್ ಏನಕ್ಕೆ ಅಂದ್ರೆ ಮಮತಾ ಅವ್ರ ಹಸ್ಬೆಂಡ್ ಅಲ್ಲ ನೀವು? ಓಕೆ, ನಿಮ್ದು ಎಂಬ್ರಿಯೋಸ್ ಇಲ್ಲಿ ಇದೆ ಅಲ್ಲ, ಅದನ್ನ ರಿನ್ಯೂವಲ್ ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಸೊ ನಿಮ್ದು ಡ್ಯೂ ಇದೆ. ಸೊ ನಿಮ್ಗೆ ಲಾಸ್ಟ್ 2 years ಮುಂಚೆ ಟ್ರಾನ್ಸ್ಫರ್ ಆಗಿತ್ತಲ್ಲ, ಇನ್ನ ಎಂಬ್ರಿಯೋಸ್ ಮಿಕ್ಕಿದೆ, 4 ಎಂಬ್ರಿಯೋಸ್. ಅದನ್ನ ನಾವು ಫ್ರೀಸ್ ಮಾಡಿ ಇಟ್ಟಿದೀವಿ. ಸೊ ರಿನ್ಯೂವಲ್ ಡ್ಯೂಸ್ ಇದೆ. ಸೊ ರಿನ್ಯೂವಲ್ ಕಟ್ಬೇಕಾಗುತ್ತೆ.
2 times ಆಲ್ರೆಡಿ ಆಗಿದೆ. ಅದೇನ್ ಮಾಡ್ತಾರೋ ಗೊತ್ತಿಲ್ಲ. ನೀವು ಯಾರಿಗಾದ್ರೂ ಮಾರ್ಬಿಟ್ಟು ನಮ್ಗೆ ಅಮೌಂಟ್ ಏನಿದೆ ಇದ್ ಮಾಡಿ. ಯಾಕಂದ್ರೆ ನಾನು ಊರಲ್ಲಿ ಜಮೀನೆಲ್ಲ ಮಾರ್ಬಿಟ್ಟು ಇದ್ ಮಾಡಿದೀನಿ. ನಾವ್ ಎಷ್ಟು ದಿನ ವೇಟ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಆಗಲ್ಲ ಮೇಡಮ್. ಅದೇನೈತೆ ಅಮೌಂಟ್ ನಮ್ಗೆ ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ.
So here the patient is basically requesting the clinic to sell the frozen embryos and compensate them financially. And as we all know, yes, commercialization of human embryos or sale of human embryos, as clearly stated by the law, is strictly prohibited.
These questions are pretty easy, but then I want to know from
How to handle the patient, I think.
how to handle patients, because these are regular cases that we come across. We can't keep on storing the embryos years after years. But at the same time, some irate patients will also speak like this. How do we counsel them? Dr. Sumana, if you can tell us, I'm sure you also would have faced such cases. Dr. Sumana, how will you counsel these patients?
Yeah, I think we have to initially itself explain to them about what the success rates are like, and they have to be realistic in their expectations, and that the financial counseling has to be done upfront, and they have to be clearly told about what the law allows and what it doesn't. So I think that a good proper counseling done before the start of the cycle, I think, will go a long way in helping us dealing with the situation better.
I think it is very well said, because upfront counseling matters a lot. Many a times as doctors, we are scared that where the patient will run off, and if we tell them all the counselings, including the success rates. So it's very important for us to spend some time in counseling, explain each and every consent, saying that what does each consent imply, and what about freezing of embryos? In fact, our lawyer was telling that we have to freeze the embryos for such and such a period. But if we go through the consent forms, sir, it is only for the specific period of time. And if they don't get back to us, whatever I have understood is we have the right to discard the embryos, right, sir?
Now, 10 years, they say you have to store the embryos according to the act. Whether they pay you or not, that's a gray area again. It is unexplained. But what I would suggest is, if they're not paying your freezing charges, they're not incommunicado, at least write letters to the address, send emails, write it on phone often that you have not renewed it, and we will go. We will at least with a small claimer that we may have to dispose the embryos or the gametes in accordance with the ART Act. Though we cannot do it, we at least word it in such a way that we will obey the act, but also slightly tell them that you have to come and be responsible with your gametes and embryos.
That's a clause which is actually mentioned in the consent also, sir, saying that if they fail.
Sir, I beg to differ with this. Sir, because in the terms and conditions, that is Form 9, in terms and conditions, point number 1, in that sub point number 2, respond to a request for information from clinic within 90 days of receipt shall constitute abandonment and signify my desire to terminate storage of cryopreserved embryos. In the event of my failure to comply with 1 and 2 above, I instruct the above mentioned clinic and hereby consent to my cryopreserved embryos either being destroyed and discarded or given for research. So in this, it's very clearly mentioned that it is for 12 months is our liability.
And correct. But now we are talking of form versus what is the law. You go to the sections, it says 10 years. Now your form says this. Now what is the practical call we have to take?
No, 10 years is if they abide by the law. If they don't abide, then there are 3 emails you have to send. That to emails only, not WhatsApp and not calls. At the interval of 45 days, 3 mails should go. Within 90 days, it's 45 days. First, 45, 90. For all the 3, if they do not respond, then the onus is not on us.
And 10 years is the maximum duration, provided that they are paying their annual charges for
what I'm saying.
But is
everything
it
is fine,
explicitly said
accepted.
like that in the act, doctor?
It is mentioned in the consent itself.
That is what I'm
Consent was
saying.
selected.
Everything
The
is fine.
problem is it is not worded properly. There is a lot of ambiguity with what the provision says and to what the consent says.
Sir, does it mean like this? It depends on interpretation, which means, see, we had cases where after the age of like 29 years of freezing, the embryos were used. It is not in India, but I think it was in US where they have used this embryos just 29-year-old. So probably that higher capping is something that they have given, saying that beyond 10 years you cannot use it.
Here,
Like how we cannot culture the embryos beyond 5 days. The
Okay.
same way beyond 10 years, the
It's
cryopreserved embryos
your
cannot be
military,
used.
it's up to 10 years. Up to 10 years.
Yes.
It has to
But
be read that way. Yes.
yes, because
Yes.
because Form 9 is in rules. So rules are execution of the law. In that, I think it's very clear that we have onus only for 12 months.
12 months. But according to that form, you are right, doctor. But the rule says up to 10 years. Because
That
there
if
is
there is no legal confusion, then it is 10 years.
Yeah.
But it is
Madam,
also
in that
expensive
condition,
to.
practically
madam,
difficult.
in that condition,
Practically difficult.
sir, in such situation, I think you are discarding the embryo is not the right way. So after, as the madam has mentioned about 3 consecutive email and other proof that we have communicated with them, and we are with all these documents, we have to write to the AIT and national board that so and so patient details has been communication has failed. They are not returned to continue their embryo, and hence this embryo will be handed over to the AIT board. It seems.
No,
Rather than
I've not
discarding.
come across. I've not come across. But how do we expect a quick response for all this from the board? We will have to depute people to go follow up the file.
Sir,
And
in such situation, they have mentioned that it has to be handed over to the board or research or discard. This rather than discarding
Sir, how is it, sir? Nirvani, sir. How are we supposed to hand over the embryos?
No, we have to take the consent from the national board about submission of all these documents.
think
Okay.
Section 28.
See,
so Datu sir, you're saying something?
Section 28, subclause 2 clearly says up to 10 years. And the form says that the procedure laid out to discard the embryos. Now we will have to take a call again and see how to go about or we do with on a case-to-case scenario. It is also practically difficult because you are going on storing embryos where they're not paying. That also becomes a problem.
Yoga Rao sir is there if anybody wants to have the opinion.
And in all this, I think embryologists are left scot-free. I think. What is the role of the embryologist? Like, every time it is a clinician who is the forefront, and we have to listen to everything. But what are the duties of an embryologist in terms of maintaining these embryos, to keep these embryos? And if at all, for example, now we have discarded the embryo after say 5 years, and then later on couple comes to claim, will the embryologist will also be in picture, or how is it?
Because the freezing facility is that of the establishment. So when you're storing something, I think the onus is more upon the establishment than the person involved in the procedure.
Madam, how the embryologist will discard the embryo without informing to the clinician?
No, sir. No, it is a joint decision that the clinic has taken.
No, sir. Sir, Dr.
So-
Diveshri is trying to. Dr. Diveshri is trying to ask. Sorry, Ray. So she's trying to ask, like, is it like only the clinician signature is required, or along with this embryologist signature is also required? We are a team.
Yeah, exactly.
Okay.
And
When it comes to discarding the embryo, I think both clinician and embryologist has to sign on that. Any documents related to embryos.
And
And then-
embryologists can do a lot of counseling also.
Yes, exactly.
Yes, ma'am.
In fact, we have to involve embryologists more and more in counseling because it is equally important, whether good or bad. It is very important for the embryologist voice also to be there in clinical counseling. It is not just that, it is also about when it comes to so many cases we are seeing now where the gamete mix up has happened. So when the gamete mix up has, it's not just one case. So many times, so many cases have come up. Every time it is a clinician who is brought to the forefront that gamete mix up has happened. So at present, there is how the law is when it comes to whenever there is a gamete mix up, whether the embryologists are also held responsible, or it is just the clinician, or it is just the establishment. How is it?
Ma'am, under both the acts, whoever the clinical director is, they cannot get away from the offense. That is a given. Now, again, now it's a chain of events. Who picked up whose sites, who froze it, who was in control of the lab, who was talking to the patient. Then the responsibility of all other people fall into place in succession.
So it's serious
Will
responsibility.
be accountable. That person is going to be the director.
Clinical director is first. Everything,
so
unless they prove that it has done, all these acts have done without her knowing, and that is in a matter of, again, leading through evidence. It is not a straight sort of an avertment or a submission. That will not help. She has to clearly prove her innocence if some such an act is done.
What's the law say in
I
other
just interrupt in that,
countries?
madam. Okay, madam. Please, Sumna, madam, go ahead.
No, what is the liability of the embryologist in other countries? What does the law say outside?
I am not aware, ma'am. My limited knowledge is to the ART Regulation Act here in India.
But it's actually quite interesting to know about, ma'am.
Dr. Shilpa, I can see Mr. Jogarao logged in.
Okay.
And has sent a message also. He's muted. If you can unmute him, probably he'll give some.
Yes.
Ma'am, we were discussing about informing the patients on
Sir is
email.
there.
Okay, sorry. Okay, so is email enough, or should we also send registered post to the patients that this is one of the embryos?
It is better we open all communication lines through WhatsApp. But anyway, it will only add to that we have tried to communicate to them. We have exhausted all our means. Still, there is no response.
Because they may say, I don't check email, my email has got hacked. So
let us use all modes of communication.
But email will have your content, whereas your post will not have your content.
There's also a clause which basically
all doctors
bounce back also is to be taken as into
all
note.
doctors who are running individual clinics or any institutions where the clinical directors are, please be aware that the embryos are your responsibility. The embryos are your responsibility. Anything can happen in future. So be very careful, especially clinical directors, how you are going to deal with these frozen embryos. And probably you have to keep an eye on what is happening. I don't know, but all the checks and balances should be under the this thing purview of clinical director. This is the message that what we have got through this webinar. I think Professor Jogarao wanted to comment on this, or
please.
He's online.
Let us have Professor's opinion.
That's what I've been telling from that time.
Good evening, friends. Am I audible?
Good evening, sir.
Yes, sir. Good evening, sir.
Good evening, sir.
Such a pleasure to have you, sir.
Thank you so much. Thank you.
Show your video also.
Yes. I am of the opinion that the ultimate responsibility lies on the shoulders of clinical director. In terms of, there is a very interesting question from one of the panelists about the embryologist's role in other countries. To my knowledge, barring in 3 countries where specific responsibility has been recognized on the role of embryologist, which is a secondary to clinical director. Therefore, in terms of Indian circumstances, for example, one person made a mention about whether embryologists can play a role in counseling. Of course, yes. Embryologists, they can play a very, very constructive role in counseling. But when it comes to legal accountability, unless there is a specific evidence as to whatever the embryologist has done either without the knowledge of the clinical director or etc., then only there may be a possibility, but otherwise the ultimate responsibility is on the shoulder of clinical director. That's what I think.
And all establishments which are run even by the corporate structures have specific clinical directors in them. So it is not, it is not a company. Here it is an establishment with the clinical director. Unless any offense has happened, the clinical director proves their innocence, it is always their responsibility and liability.
Yes.
Thank you, sir. Thank you for that, enlightening words from you. I think, Dr. Shilpa, we are
with the session, ma'am.
I think we should close because
how to
1
start
hour is over.
Right.
Pardon? Because otherwise, Professor Joga Rao's talk also will get delayed.
Yes, ma'am. So thank you.
Thank you, our wonderful panelists. It was such a nice thing to have you all, because we covered most of the cases and we have got to take home points. So, Dr. Shilpa, if you can just cover up with the take home points, we can close.
I think we have had a very fruitful.
And special thanks to Professor Joga Rao.
Always.
Thank you so much, sir.
Thank you.
So if there are 2 or 3 take-home points that I would like to, yes, on behalf of my co-moderator and the panelists, give to the audience. Definitely the ART Act 2020 strengthened our practice through regulation, most importantly, transparency, accountability, and patient safety. But yet certain provisions of the Act always lead to clinical, ethical, and legal challenges that we have to be taking up on a case-to-case basis. However, needless to say, I think meticulous documentation is the cornerstone of medical legal protection for both patients and clinicians. And every medical case is a learning opportunity to improve protocols, strengthen ethics, and deliver safer fertility care. So with that, I would like to conclude the panel discussion.
Madam, I have need one clarification from the advocate side.
Yes, sir.
Yeah, last time I was just attending one webinar regarding the same legal. There it has been mentioned for the donor oocyte pickup. So after the amendment of that, all the oocyte has to be retrieved from the donor instead of 7 oocytes giving it to the intended couples. So in my way, what the legal advocate said that it is said that, however, you have to retrieve all the oocytes, but only 7 matured oocytes should be given to the intended couples or the recipient. So remaining oocyte, whatever the retrieved, has to be discarded. So my thing is, suppose if 7 matured oocytes were given to the couple, in case in any circumstances, if like we end up with no good embryo for transfer to them. So by that time we have already discarded the remaining oocyte. So how to address the patient, like after forming the embryo, after conception, we need to discard that, or in the same cycle it has to be discarded? How to go ahead this one? I hope my question is clear.
I am unable to really.
Sir, can you hear me?
Yeah, you are audible, but somewhere down the line from my end, I am unable to comprehend what you are trying to project.
That, sir, in case of donor stimulated retrieval condition, donor oocytes.
Okay.
So the advocate mentioned that once the retrieving of the oocyte, suppose you have to retrieve all the oocyte, whatever the stimulated during the stimulation. So they are saying that only 7 matured oocyte should be given to the couple recipient. Okay, and remaining oocyte, suppose if you received must be discarded. So my question is, suppose in embryology, in the lab, whatever of the patient end up with no good embryo for transfer after sharing the 7 oocyte to her. So by the time we have discarded all the remaining oocytes which were retrieved during the pickup. So how to address the patient that you don't have any embryos for the transfer? Either the embryo can arrest or any infection or fertilization failure, whatever the means. Ultimately, the patient will be having no embryos for transfer. So how to address this one? Because as per the law, we have to give only 7 oocytes.
My response to I think there is definitely a dilemma in your question, which now I understand. As per the mandate, the 7 number is something very clear. And in case if there is no positive, etc., if the patient challenges you or seeks clarification, we need to clearly mention what is the legal mandate. That's all, nothing else.
Okay. But however, we are discarding the oocyte unless there is formation of complete embryo or a blastocyst which you are going to do the transfer or which can be frozen also. So unless complete oocyte or embryo forms, then later we can those remaining oocytes can be frozen after 7. And once the embryos are formed, then we can discard that remaining oocyte, no sir?
I doubt whether the current law recognizes what you are saying.
Okay.
I don't think, unless there is an amendment to that effect or a judicial interpretation to that effect, as you were saying, can we not keep, and depending upon the result, can we not discard? I think currently that is not possible.
Okay, okay, sir.
That's what I think.
But practically, I'm like, to be safer side, many of the clinics, I'm to say, that they freeze the oocyte unless they form, they officially, like on post, we have to give 7 oocyte to them, and then once the embryo is formed, then they can discard the oocyte, like what I feel like they are practicing.
In fact, I do understand in couple of seminars, these questions have cropped up. My point is, as Dr. Shilpa Reddy very aptly put it, this is a legal framework. I don't think there is a finality as such as of now. Still, a lot of things I know. ART Act and Surrogacy Act, there are so many judicial decisions in this country in the last 2 years, more than 25. Therefore, there is a need for revisit of the law, which I think these practical considerations need to be taken note of. That's what I think.
Yes, sir. Thank you.
Thank you. Thank you.
Panelists for such a wonderful discussion. I thank Dr. Divishri and Dr. Shilpa Reddy for putting together these questions and these case scenarios. I'm sure many of us would have liked to continue discussing a lot more scenarios. So there's, we face so much of these medical legal questions, so much of these gray areas that we really want to ask and discuss. But I think we can take it on, at a later stage. So thank you both, and thanks to all the panelists for enabling such a wonderful discussion. Now we will move on to the next presentation by Mr. Jogarao Sripada. So welcome to you, sir, and we are waiting to hear from you. And I'd request Dr. Rekha Rajendra to introduce her, please.
Yeah. Thank you, Dr. Mangala, again. Sir is such a well-known figure, and we have had Sir's input in many of our conferences. Sir, Professor Dr. S.V. Jogarao is presently anchoring the professional activities of Legal Excel Attorneys, a law firm of advocates, solicitors, and healthcare consultants based in Bengaluru. He is the founder of Legal Excel Attorneys. His teaching career spans over 3 decades. He joined the National Law School of India University as a founding faculty member in 1988 and contributed extensively to teaching, research, and academic administration, as we are all well aware of. He predominantly taught in the areas of contracts law, criminal law, evidence law, healthcare ethics and law, which we are really interested in, transfer of property law, as well as contractual structuring and risk management. He participated in several national and international research projects, seminars, and workshops. He is a recipient of British Council Fellowship and the Max Planck Fellowship. After more than a decade in academia, transition to legal practice in 2001 as an advocate and healthcare law consultant. Dr. Rao was invited to serve on the expert committee constituted by the government of Karnataka to review and recommend changes to the new criminal laws enacted by the government of India. The committee's report was subsequently endorsed by the government of Karnataka and shared with the government of India. What I expressed here is a very minuscule of Sir has a lot of accolades. We are all very sure of that. It's a very brief introduction of Sir, and over to you, Mr. Jogarao.
Thank you, Dr. Rekha. Thank you so much. Friends, this particular theme that has been selected for my presentation is a very important development in our context. I thought I'll just pose a question before I start my presentation. What is DPDP Act? What is the full form of the act?
The Digital Personal Data Protection Act of 23.
Yes, perfect answer. The answer comes from
ART specialist.
He is absolutely right. The Digital Personal Data Protection Act 2023. ನಮ್ಮ ದತ್ತಾತ್ರೇಯ ಅವರು ಆನ್ಸರ್ ಮಾಡಿದ್ದಾರೆ. Now the point is, why ART specialists need to know about this? I think that is something we need to. I could not speak to her directly. I am thankful to Dr. Kartiga Veni, who approached my daughter, and that is how the entire thing has been finalized. DPDP Act and rules, they have a profound impact on healthcare sector in general and ART clinics in particular. That is something I want to share with you. For instance, whether you are in a position to see my screen?
Yes, sir, we can see it.
But whether it is the first screen, I don't know, it's not moving. The only first screen is there.
First slide.
And
first slide, I mean, yeah.
Okay.
Yeah, now it is moving,
now,
yeah.
Yes. Digital Personal Data Protection Act 2023 and Rules 2025, they provide a comprehensive framework for protection of digital personal data, balancing individuals' privacy rights with lawful processing requirements for organizations. When we say organizations, we are referring to hospitals, clinics who handle patient digital data. More importantly, the DPDP Act and rules, they provide for compliance obligations. I think that's where every one of us, we need to be very, very clear. Is there a constitutional foundation? Yes. Right to privacy is recognized as a fundamental right under Article 21. And in our day-to-day life, without there being digitized communication or information, our life doesn't start and doesn't end in a night. And consequently, the vulnerabilities of technology-driven processes also indicate not only the digital errors, but also growing cyber security and privacy concerns. Need for data protection law is felt because of all these multifarious factors. No doubt in Indian context, we have enacted Information Technology Act 2000. which primarily recognized legally the electronic documents, the electronic records, signatures, etc. But the need for protection felt of late. That is the reason why we have enacted the Act 2023 and a lot of debate, scrutiny. The rules 2025 have been notified in the month of November. Please remember, in several respects, the Act and rules, they align with global standards. Are there any objectives? Yes, there are several primary objectives. Number one, protection of digital personal data, protection of individual privacy. My dear friends, the information what we share with a platform is something your own private information, depending upon the kind of platform, the kind of service that is being sought. Naturally, for example, a bank or a financial institution, the information about your personal finance, it is a private information. Suppose you want to register your son or a daughter on a matrimonial site, that involves the personal information. In that way, health information is personal and sensitive information. And please remember, the data, what you are handling, it warrants responsible processing. And the organizations who handle those processing must be made accountable. Then only promotion of digital economy enhances. Facilitation of innovation and business growth, both must go hand in hand. And accordingly, if my data got breached, naturally, I must have remedy and I must seek protection against unauthorized use. DPDP Act, my dear friends, there are 5 important aspects. One is data principle. In our context, the patient who shares information, either during consultation or informed consent, etc., is the data principal, because the data belongs to him or her or both. Data fiduciary, the organization which determines the purpose and means of processing personal data, which is nothing but ART clinic or a hospital. Data processor, please remember, entity is a legal status, but the people employed by the data fiduciary are the data processors, which includes even concern manager. Depending upon the volumes of data that gets streamlined, stored, and processed, DPDP Act recognizes a significant data fiduciary. For example, an organization like Amazon, which deals with millions of customers, it can be, it is recognized as SDF. And accordingly, the central government has to prescribe rules with regard to that. Are there rights of data principles? Of course. The person who owns the information has multifarious rights. Number one, right to information. He or she is entitled to know what personal data is processed. Right to correction. There is a possibility a given data may require correction under certain circumstances. The opportunity must be given. Right to erasure. I am entitled to forget the past. In such a case, I am going to explain maybe after a couple of slides, in the context of ART clinics, what happens, how it can be. Right to grievance redressal. My complaints must be heard. There must be a system. And finally, depending upon my choice, I am entitled to nominate a person to represent my interests. Data fiduciaries means clinics and hospitals. I hope you are aware, DPDP Act is applicable cutting across sectors. One such sector is healthcare sector. Key responsibilities include lawful processing, obtain valid consent, maintain data accuracy, protect personal data, implement security safeguards as prescribed, respond to data principal requests, ensure processor compliance, delete data upon withdrawal of consent where required. I, as a data principal, I, as the patient, I am entitled to withdraw my consent under certain circumstances. Accordingly, the fiduciary must act responsibly. My dear friends, the most stringent part of this act is indicated in penalties. Failure to implement security safeguards up to 250 crores for the organization, that is fiduciary. Failure to report breach. Please remember, as and when a breach takes place, the fiduciary is under an obligation to inform the principal, indicating the report incidents and the activities and future prevention, which means it is going to be a heavy financial burden on the organizations / fiduciaries. Therefore, the compliance is something highly inevitable necessity. What is the roadmap for organizations? Number one, you need to assess in phase one data inventory, gap analysis, and risk assessment. Second, governance. How do you deal with the situation? You need to have a formulation of policy. For example, privacy policy, consent framework, and vendor contracts. Please, for instance, ART Clinic, you have a vendor contract with a particular software supplier. In such a case, you need to see whether there is a possible potential leakage of information. If so, how do you protect your interest by risk management? Thirdly, security, purely technology driven. Technical controls, access management, monitoring systems. Access management is very important because you need to know who is accessing the information of the patient data. And finally, you need to operationalize. How do you do that? Training, incident response, and audit readiness. All these four phases constitute the core competency capacity building for the organizations. What are the takeaways? Know your data, obtain valid consent, provide transparent notices, particularly to the principal, respect data principal rights, implement strong security, manage breaches effectively and timely response, govern third-party processes, build privacy by design culture. Ultimately, please remember, privacy compliance now a board-level responsibility. It is only because the kind of penalties the act and the rules envisage, they constitute a significant burden. In the backdrop of this DPDP Act and rules, I just wanted to contextualize in terms of ART clinics. Are there any implications? The first thing is, of course, there are implications. Please remember, DPDP Act is applicable under two important circumstances. Any information which is digitized or any information which is written but subsequently digitized. In both the cases, all the organizations handling the data, they are bound by the DPDP Act. To my mind, ART clinics, because these clinics routinely process some of the most sensitive categories of personal information, like infertility records, reproductive histories, genetic information, donor identities, embryo data, cryopreservation records, and treatment outcomes. All these constitute personal, serious, sensitive information. Why ART clinics are high-risk data fiduciaries? This is something very, very significant in our social, cultural context. Because ART clinics collect and process medical records of intending couples, genetic and reproductive health data, donor information, embryo creation and storage records, fertility treatment histories, pregnancy outcomes, and cryopreservation records. My dear friends, all this information, all this data, what you collect, have serious social, cultural implications in the form of, for example, marital relationship, reproductive autonomy, social reputation, employment prospects, family relationships, and more importantly, genetic privacy. In view of this, ART clinics are the most important fiduciaries. Current requirements. I mentioned informed consent. For example, ART clinics generally, this is before DPDP Act. treatment consent forms, IVF consent forms, donor consent forms, etc., etc. But however, after DPDP, the consent must be free. In fact, word free does not mean no economics. No, free means voluntary, specific, informed, unconditional, unambiguous, which means a single blanket clause stating I consent to treatment and use of my data may no longer be adequate. You need to, while complying with DPDP Act, has to generate a compliant consent form. Impact on donor anonymity. I mean, that's what even respective acts say. Sperm donor, suicide donors, embryo. The ART Act mandates confidentiality regarding donor identity. That's what precisely DPDP Act also does. But there is a very, very important information here. Donor information must be processed only for lawful purposes. Access controls must be implemented. Disclosure must be restricted to authorized persons, which means the fourth phase, how do you operationalize this particular, as I mentioned, the policy must be put in place, the persons must be trained, and audits must be conducted so that these things will be taken care. ART clinics must ensure segregated donor databases, role-based access, encryption of donor information, and audit trails for access. This is where, as a fiduciary, the most important responsibility, suppose in the likely event of a breach, you need to conduct investigation, because the violation must be reported to the Data Board of India, Data Protection Board of India. Therefore, all these aspects, investigation, reporting, informing data principle, must happen immediately. Any unauthorized disclosure may expose the clinic to DPDP penalties, which is very huge responsibility, ART Act violations simultaneously, and possibly even consumer or civil liability as well. Data retention eraser rights. This is something, there is a very interesting conflict. For example, DPDP Act grants data principles certain rights related to correction erasure. What do you mean by erasure? For example, as a patient, I approach you for a particular service and I did not succeed in getting the relief. I want you to erase or delete those records of that period. But please remember, there is a practical difficulty. The ART Act and ART rules require maintenance of records for a prescribed statutory period. For example, a patient requests deletion of all IVF records after an unsuccessful cycle. The clinic cannot simply erase the records if statutory retention obligations continue. The appropriate response has to be, records cannot presently be deleted because retention is mandated by law. My dear friends, even under DPDP Act, right to erasure is subject to certain exceptions. For instance, a particular patient's relevant care disease details, as a hospital, you have to inform concerned authorities under Notifiable Diseases Act. In such a case, right to erasure cannot prevail over your statutory obligation. Therefore, same thing, because under ART law, you are bound to maintain the records for a particular statutory period. If the patient asks, please remember, you have to inform in writing that erasure is not applicable because the records need to be maintained. Therefore, what is the responsibility? Clinic must therefore develop data retention policies, data deletion policies, schedules, and record archival procedures. I think this is something very, very crucial. Data breach obligations, my dear friends, they are very, very, very complex. ART clinics are particularly vulnerable to ransomware attacks, unauthorized employee access, cloud storage breaches, email leaks, misdirected medical. Under the DPDP Act, upon a personal data breach, the clinic must notify the affected data principals in writing, the Data Protection Board, in accordance with prescribed requirements. Therefore, the best thing to happen is to prevent at any point of time data breach. If it happens, the consequences are very crucial. For instance, an IVF clinic server is hacked and donor records are exposed. I mean, we have come across these kind of things in recent times, several occasions. Potential consequences to include regulatory investigation. Data Protection Board of India may enforce and accordingly constitute penalties under DPDP Act, reputational damage, and potential litigation from the impacted individuals. I think these are the consequences which need to be taken note. Therefore, in addition to these, your third party vendors and cloud platforms, those agreements you need to be. For instance, IVF software providers, electronic medical record vendors, cold storage services, all those contracts, the risk management, who is responsible for what in the event of data breach, indemnification clauses, bilateral, mutual indemnification, all those things must be put in place. Under the DPDP Act, clinics remain responsible for data processed through such vendors. Therefore, clinics should execute data processing agreements, confidentiality agreements, cyber security obligations, and incident reporting clauses. My dear friends, I must tell you, this particular act, which is a comprehensive legislation, which balances individual privacy rights and organizations' accountability, please understand the accountability on the part of organizations like hospitals, clinics as fiduciaries, they are far outweigh the kind of other consequences. Therefore, the time is ripe and deserving for all the clinics and hospitals. They must create sensitization measures, subsequently develop into capacity building measures, and then have an ecosystem where all the stakeholders like clinicians, IT, law, and other people, so that a proper comprehensive system is put in place which complies with DPDP Act and rules. Thank you.
Any questions to Professor?
Yes, any questions?
Sir, I have a question. I'm Dr. Mangla here. So I just want to know if right now we see a lot of centers marketing online. So sometimes we put up patient testimonials. Of course, we have taken the consent of the patient while putting up these testimonials, and I mean we kind of let out their identity, but they're grateful or thanking the doctors for whatever we have done. So that's the kind of open us to being sued under the DPDA.
Yes, undoubtedly. I mean, with the authorization, I mean, with the consent authorization protects your interest. There is no doubt in that. You are referring to testimonials as and when given select patients who share that information with
you. Yeah.
Therefore, the consent and authorization protects your interest. There is no doubt. But having said, we means all of us, we need to revisit those practices in the light of DPDP Act. Because whenever there is any potential breach, as a fiduciary, as an organization, you are responsible. Therefore, at every level, we need to look into what is the process and the consent and the particularly IT related technology driven safety safeguards, etc. They must be put in place so that the vulnerability of breach doesn't happen.
So it may not be willingly, no, sir. We have put it only as a means of marketing, but just in case, considering that information that we put up or their identity is used or misused, so will the IVF clinic be liable for it?
In my opinion, if there is a consent to that effect, for what purposes you are processing, handling, and putting it across.
Okay.
If there is a consent to that effect, there is no vulnerability, your interests are protected. But I am saying under the DPDP Act, we need to revisit those practices. In what way it has to be? For example, consent forms, no doubt we have spoken for years, but still the content is something we need to be very, very careful. That's how we need to protect our interest.
Written consent.
Yes, of course, of course.
Professor, just requesting you to throw some light upon the offenses under the DPDP Act.
The offenses include either in terms of a third party committing a breach whereby your patient data is either sold or accessed by various other people. Number one. Number two, there is a possibility it is not an outsider vendor, it could be your own organization, fiduciary employee who sells that information to third party. Third, there is particularly DPDP Act very focused manner handles children's interest, children related information. And accordingly, it says anything if they are targeted for advertisements, etc., that is a serious violation if there is no parental consent. In that way, breach could be either one individual or community or other, either third party or your own organization. Simple thing. For instance, WhatsApp we share, sometimes clinicians share messages, etc. Nobody has the control to whom it reaches. Nobody has the control. In fact, every one of us, we like forwarding in such a manner without taking proper safeguard, we do that. And I can tell you, it plays havoc for the fiduciary and the hospital if those things continue to happen. These are the offenses. And sir, one thing I can tell you, in the history of penalties, no doubt one word they have used up to, they said. But we know, majority of these organizations have a kind of industry status and a commercial motive. Therefore, the way adjudicating officer, that is Data Protection Board of India, they are going to handle, I think it's going to be. Therefore, I don't think we should wait for any breach to happen. We must preempt breach to happen.
Yes.
That's what I think.
I also, in my limited opinion, sometimes feel to the advancement of information technology and medical technology, we don't have the laws and procedures, Professor, in my limited opinion.
You are absolutely right. You are absolutely right. In fact, we don't have a comprehensive, even now. DPDP, no doubt, DPDP Act is applicable to banks, financial institutions, education, hospitals, hospitality, you name any organization. But we need a comprehensive for healthcare sector. That we don't have. As a consequence, every one of us, we face a lot of issues and several gray areas, etc. I will put it this way. India is such a vast and diverse country. I don't think every ART clinic or every chain thing cannot be compared with a pan-India appearance of corporate hospitals in India. Pan-India hospitals, 250 crores, that's all they will say. But whereas an ART clinic based in Bangalore, Sadashiva Nagar, 250 crores means it's a death knell for the company.
Please, yes, yes.
Therefore, we need to be very careful. But having said, I am told some review may be possible. That's what they are thinking, particularly penalties and offenses. Therefore,
the law will evolve, Professor. Yes, yes.
Yes.
Anybody else has questions? Shall we close this session? Professor Jogarao, I'm Dr. Rekha Rajendra Kumar from Chandana Hospital, Nagarbavi, near Center. We are old friends, if you remember.
Yes, I remember.
Mrs. Joyara also. Yes,
Yes,
sir.
yes,
Fine.
yes.
Thank you, sir. Fine.
Pleasure.
With professor, that's the only thing we have to tell. One apt thing to tell him today as we close is: you give a man a fish, he is satisfied for the day. You teach a man how to fish, he is satisfied for life. You have satisfied many of our lives, sir.
Thank you, sir. Thank you. Really nice of you. Very.
Yeah.
Thank you.
Thank you, sir. We'll keep in touch.
Thank you. Thank you.
Thank you. Thank you, sir. Yeah. We move on, Dr. Mangala.
Yes, please ask. I request Dr. Karthikeyani to speak on the next session, please. Can you put on her slides, please? Dr. Karthikeyani is a fellow in reproductive medicine. She's also a consultant at Bangalore Baptist Hospital. She has presented several papers in various national conferences, and she's a member of several societies. Her areas of interest are poor responders and RIF. Over to you, Dr. Karthikeyani. Dr. Karthika, due to time constraints, I request you to keep your presentation short because the central team has another meeting on the
And
same.
please unmute yourself. You have been talking muted.
I have unmuted, ma'am. Good evening, everyone. Now I will talk about the telemedicine practice guidelines and its impact on assisted reproductive technology. So first, the overview of the session. I will talk about first the introduction. Then we will move on to the historical perspective of telemedicine and regarding the telemedicine practice guidelines, then how it is applied in ERT and what are the recommendations and what is the future of telemedicine. And first we will see the conclusion part. So what is meant by tele? That is, it is a Greek word that means far or at distance. And WHO has given the definition of telemedicine, that is the delivery of healthcare services by all healthcare professionals using technology for diagnosis or treatment or prevention of disease. So the aim is to advance the health of the individuals and communities. So why telemedicine matters in India? Because if we see the doctor to patient ratio, it is only 1 in 1,400. And also most of the healthcare workers are in the urban population. That's why telemedicine is very important in our setup. And how it has evolved, it is way long back. In 1920s and 40s, ships were using that. And after that, astronauts were using that. And in India, if we see in 2001, ISRO was the first who connected remote hospitals with a specialty center. And in 2018, there was a Bombay High Court case where a doctor couple was held for criminal liability because they prescribed some medication without a proper diagnosis over telephone. And so that time they thought that there are a lot of gray area in the telemedicine. So they thought that we have to put up a legal framework because there is a lot of uncertainty whether telemedicine is legal or not. So as a turning point in March 2020, telemedicine practice guidelines came. And it was introduced first by the Ministry of Health and Family Welfare, and later it was incorporated into the National Medical Commission Act. So the regulatory pillars of telemedicine, the regulation, if we see, it includes NMC Act and Telemedicine Practice Guideline, because if we are prescribing that, the Drug and Cosmetic Act also it's included, and also DPDP Act, and the government health policies regarding the digital health mission, that is also involved, and regarding the telecom regulations is also involved, which is involved revolving around the telemedicine guidelines. So telemedicine practice guidelines in March 2020, it was given in one partnership with the Niti Aayog, that is National Institution for Transformation of India. And the key definition, they gave the definition of telemedicine as per the WHO definition. And telemedicine means it can be done only by a registered medical practitioner for clinical services. But telehealth, it includes telemedicine, and also it is related to even educational content or any other health informational services. And what is the advantages? There can be any timely access, and cost, because of travel expenses are less, cost is less, and there is high degree of maintenance of records, and also in pandemic situations to prevent transmission of infection, this is of helpful. And there are 4 basic types of telemedicine. One is by considering the mode of communication. It can be video, audio, text, and timing of information. It can be real time or asynchronous, and purpose of consultation. It can be first time or follow up or emergency consult, and individuals involved. It can be from the patient to the practitioner, or from the caregiver to the practitioner, or from the practitioner to practitioner, or health worker to the practitioner. So first consult means if the patient is consulting for the first time, or after 6 months, or for a different health condition. And follow up consult means it is if the patient is consulting for the same health condition with the same practitioner within 6 months of continuation of care. And there is emergency consult, and it can be of video, audio, text, and asynchronous. Video is of very helpful because we can have an identification, and visual cues are possible, but there are privacy concerns. Next comes the audio. Audio is fastly delivered, but the non-verbal clues can be mixed. And text, it is quick and convenient, but visual cues and verbal cues will be missed. And asynchronous, it is not real time, but it is easy to send the images and reports and all. And which are the elements of telecommunication which should be considered? The practitioner has to decide what like they should use their proper discretion, and they should not compromise the quality of care. First, they decide whether telemedicine is appropriate or in-person consultation is needed, and both of them should verify each other, the patient and the practitioner. Consultation cannot be anonymous, and practitioner decides whether to go ahead with video, audio, or text consultation. And then it could be implied if the patient initiates, or explicit consent if the practitioner initiates. And it can be a first time consult or follow up consult. And first they have to evaluate take the history, do the examination. If it is video consult, just observation, and they have to verify all the investigation report. Accordingly, they can according to their professional judgment, they can give counseling, or they can prescribe medicine as per the guidelines. So the guidelines has told that list of medications can be prescribed on any mode of consult, and list A medications only by video consultation it can be prescribed. And list B medications, only the follow-up add-ons can be prescribed in list B. And prohibited medicines are narcotics, this and all should not be prescribed. And without any appropriate diagnosis, if we prescribe any medication, it amounts for professional misconduct. And the ethical considerations are they should follow the IMC regulations, IT Act, DPDP Act, and also if there is any breach because of third party or technology breach, then they will not be held liable. But the misconduct comes when we are soliciting the patient for advertisement or misusing patient image, then we are liable. And we have to maintain all the records of the interactions, and the fees as per the in-person consultation, we can collect the fees, and also we should provide a receipt or invoice. And all the practitioner must undergo a mandatory online course within 3 years of notification, but till now it is not there. And how the consultation can happen from the patient to the practitioner, that if the patient initiates the consult, or from the caregiver to the practitioner. First, the family member authorizes the person, they have to obtain the consult. Then it goes to patient to the practitioner consult, and the healthcare worker can get the consent of the patient, and then they can provide the details and discuss with the practitioner. And practitioner can discuss with another practitioner regarding any treatment or diagnosis. The treating practitioner remains responsible, and in case of emergency situation, they can give only the first aid and counseling. They must referred for inpatient interaction at the earliest. So the essential principles are the practitioner can choose not to proceed at any time, and they can refer for inpatient consultation anytime, and the patient has a right discontinue the teleconsultation at any time. And for the platform, they have given the guidelines that only registered medical practitioner can do the consultation. They must display the name, qualification, registration number, and the AI cannot platforms cannot counsel or practice. And it must report if there is non-compliance to the Board of Governors of MCI. And the Board of Governors of MCI also, they can modify the drug list from time to time. They can also give advisories, and they can also guide regarding amendment after notifying the central government. And they gave the sample prescription format also, what all things should be in the sample prescription format. After the consultation is over, the practitioner must transmit the photo, scan or digital copy, signed digital copy via email or any messaging platform. And as one of the studies says that like exclusively it should be done only, it is for only for registered medical practitioner. Till now there is no extra certification is needed. Maybe in future it might come. And always identification is very, very important, and consent is important, and clinical discretion and safety is the first regard, and data privacy is very important. And the any misconduct should be reported to the state medical council, where the practitioner is present at the time of consultation. And in terms of fertility, how it is affecting the fertility, we will see the application of infertility practice and how it is impacting the ERT services, and what are the challenges, what are the legal considerations, and what the evidence suggests, and the future and recommendations. So application is, maybe we can do the initial consultation, we can collect the history, and we can see the previous reports, and we can tell them to do what all test can be done, that we can do. And pre-testing can be done locally, and we can interpret maybe another time in the consultation, telemedicine consultation. And as per that, the treatment plan goes on. We will just counsel them like what is the future plan, like how the treatment goes on. The counseling can be given, and scans can be done remotely. Wherever the patient is, they can do the scans, and they can upload the scans, and we can prescribe the medication. But medication injections cannot be prescribed as per telemedicine guidelines. So we have to keep in touch with nearby a practitioner, so we can tell them to prescribe. And in clinic processes, the patient has to come to the clinic. Then follow-up consultation can be done in telemedicine. And throughout the journey, the psychological support and fertility counseling can be given. So the impact is it has a lot of positive impact, because accessibility is more, and the patients they will continue the process of treatment very good, and the cost is also less. The patient satisfaction is more, and there is an expanded reach for the patient. So ART centers can adopt hybrid care model along with that is virtual along with the physical visit. So what are the challenges? Is clinical challenges, we cannot do the physical examination, complications we cannot assess, and technical challenges are there, internet poor connectivity, and legal challenges, any cross-border issues can happen, and ethical consideration, data breach can happen, or identity verification might missed, and social or any digital literacy barriers, if they are not able to access, then that is a barrier. And ethical and legal considerations are the informed consent, the patient should understand the risk, benefit, and the limitations of telemedicine. And confidentiality, strict confidentiality should be maintained, and we have to follow telemedicine practice guidelines, DPDP Act and the IT Act. And doctors are liable for any professional negligence. And if we combine it with the ART Act, both deals with the patient welfare, documentation, confidentiality, and for the informed consent. And as per ASRM Ethical Committee opinion in 2024, they also has said informed consent, documentation, protecting the privacy, and say, to use a secure platform, and it should be used for only counseling, follow-up visit, and medication review, and for the routine conversations. Otherwise, we should call for in-person care. And one of the study published in 2024, they have taken 11 studies of 4,000 patients. They said that telemedicine is equivalent to in-person care for assist ART related procedures, and 91% of the patients showed a high satisfaction. And another study published in 2025, they have examined across 8 obstetric domain. They saw the healthcare perspective also. They said midwives were they valued telehealth for improved work-life balance, and younger professionals showed technical proficiency more than the older professionals. And 92% of the patients showed satisfaction, and they had a reduced travel time. So we can make a hybrid care model, that is combining in person with virtual approach for fertility practice. And another study in 2025, they have also said that like ongoing pregnancy rates, where there is no difference between the people who have come for in-person consultation and for telehealth. And also telehealth people, when they came for first time in telehealth, for them the 45% they had a less chance of to complete the diagnostic testing. That is, the retaining of the patient is more if we opt for telehealth, the telemedicine consultation at the first time. And what could be the future of tele-ERT? There might be artificial intelligence regarding ovulation prediction or IVF outcome prediction can be used in the future, or remote monitoring devices will be used in the future. And then mobile platforms services can be provided. And the future is to go ahead with the hybrid fertility care model. And the recommendation for the fertility specialist is to follow telemedicine practice guidelines strictly, maintain complete documentation, obtain informed consent, and use secure platform. And for ERT clinic, they have to develop telemedicine SOP, train healthcare staff, and implement cybersecurity measures. And for policymakers, create tele-ERT specific guidelines to strengthen privacy policy and promote digital health infrastructure. And as a whole, it's a telemedicine. The recommendation is that expand the applicability. Maybe instead of only registered medical practitioner, maybe for other nurses and other healthcare professionals, dentist also it can be provided. And a minor after particular age, maybe without the parental guidance, they can have a consultation. And the privacy and consent is very important. And the flexibility in prescribing the medications that can also be included. And in future, maybe a universal electronic health record system can be maintained. And the public should be given awareness about the telemedicine importance and what are the guidelines, what is followed. And conclusion, we know telemedicine is means we are using technology for diagnosis and monitoring. Telehealth is a broader framework which includes telemedicine. And telemedicine practice guidelines has brought a lot of changes. So the regulation has been adopted. So always the professional judgment comes first, then the identity and consent is important, and drugs should be prescribed as per the guidelines, and we should document everything. And this telemedicine is used we can use only to enhance the standard of care. We cannot replace the standard of care. In always the patient-physician relationship remains the central. Thank you.
Thank you, Dr. I though you made to rush through the topic, a lot of points were very clear, and you have given us a lot of information on telemedicine. I just want to ask you one quick question. So, which aspects of infertility care can be delivered safely through telemedicine, and which do you think should be given in person? So, is there some specific things which we have to do in person and cannot be done as far as infertility practice is concerned?
Fertility practice, the medications that we have to only give. We cannot prescribe via the like telemedicine platform. As per telemedicine guidelines, we cannot prescribe the medications. And the scans, maybe we can tell the patient to get the scans in the nearby clinic, and then we can see the scans. But we cannot prescribe the medication to the patient. Only we can ask another practitioner who is in the nearby any clinic or hospital. We can prescribe the medication to them so that the patient can go and collect from them. But for the consent, and then if the patient has to come in person for the consent also we have to check the person, the identity of the person. Then only we can take the consent. Then only we can start the medication. And also if the patient we suspect any complications like OHSS, then also we can do the telemedicine. But we cannot as per examination only we can decide like whether it is really a complication which should be treated or not. So that and all we have to call in for in person. But otherwise the counseling can be given, and the initial investigations can be given, and the report we can see, and we can give any common medication if they have any common illness. Otherwise we have to call other things for the in-person consultation only.
Please stop sharing your screen first.
What another? So that means to say that we can share embryology reports, radiology reports, everything. Is it on?
We can share only in a platform. Like if there is a it's not in a WhatsApp, it's not in email. Email also we have to attach with a center, with a like a ERT center. Then
I mean, you have a
via
corporate email account. What you mean?
Then we can do. Or else in the personal IDs we cannot use. Only from the hospital setup we can use that.
It is, you mean to say no prescriptions to be given, right? Please stop sharing your screen now. We can't give the prescription. That's what you told,
yes,
no?
yes. Yes.
Okay.
As
So
per telemedicine
should be
practice
there.
guidelines, they have told only the certain medicines.
What about
We cannot give ART related medicines in teleconsultation.
towards use of donors and donor gametes that cannot via telemedicine platform?
Ma'am, we can use the telemedicine platform, but the confidentiality should be maintained. Maybe it could be video consultation. The confidentiality should be maintained. Data protection should be maintained. Then in a platform, we can speak about it, but not in a, they said that in a particular platform where the health the health mission, that digital health mission, everything is included, that is it is protected by the data that we can use, or else we cannot use our personal email IDs or personal WhatsApp, or personally we can do anything in a platform where it is secure, and in a hospital setting we can do, where the data is protected, and it should be recorded also. It should be, if we are going to start, if it is patient is initiating the the contact, then it is okay, but we are going to call the patient, then it should be recorded, that is an explicit consent. Then we have to record that we are calling the patient, and the initial part of the consultation we can record audio or video, we can record that we have to ask them that are you okay to go ahead with the consultation, or else we have to put up a message, means they have to tell us, or we can put a mail that they are okay to go ahead with the consultation if we are going to initiate the consult. If you want to tell any report, or if you want to do some counseling, then we have to record that also.
Okay. Thank you.
Ma'am, is there any set of medicines which you can give on teleconsultation? Where will the list available, ma'am?
List they have given in the telemedicine practice guidelines only, they have given the list of medicine, only list O, list A and list B, and we can prescribe that also. They have said in list O we can do, but it is only over the counter medicines we can give, and this letrozole and HMG and all we cannot give, that is not over the counter medicine.
OTC,
and that list,
the OTC drugs, only the OTC drugs probably they have put the list which is available to the patient, right?
No,
list two.
Not just OTC, there are different medications in the list.
No, that's what I'm saying. It's like OTC drugs which are available, similar, not all drugs are available to the patient, whichever is listed, which may be outside the domain of ART also, like other branches also. It's a prescription list.
So list A and list B also. List A, they say only video consultation, only for eye problem, eye related issue or ear related issue, skin related issue, we can prescribe. Or the follow-up medication for hypertension, diabetes, we can prescribe. So in the telemedicine practice guidelines, they have not told about anything related to ERT related any medication. So we cannot prescribe via telemedicine. And maybe the ART Act, if they tell specifically telemedicine can be done, then only we can prescribe the medicines. As per ART Act, they have not told anything about the telemedicine. So we cannot prescribe the medications via telemedicine.
Probably it is more beneficial to the patients of like psychology counseling or this dermatology problems or radio diagnosis. Those things will be more clear compared to our branch. Those patients will be more benefited, I feel, no, with telemedicine.
Yes. We can maybe initial consultation we can do, and we can tell them to do the test and all. We can tell them to review back, and the scan we have to do, and maybe the psychological counseling. If we want to review the reports, we can speak to them. Otherwise, they have to come for inpatient consultation for the prescription. We cannot give the prescription via telemedicine, whatever mode it might be.
Any additional rules for the international patient?
Telemedicine practice guidelines is they have given only for Indian scenario. A registered medical practitioner can do within any state within India.
No, the
they have excluded international patients as per the guidelines.
Okay.
Maybe that telemedicine we have to, if they are international patient, maybe we have to follow what that country says. But this guidelines is only for it will be applicable only inside our country.
Okay.
Okay, thank you, Dr. Karthikeyani. I'd like to thank every one of you for making this entire scientific session a very successful one. I'm sure the speakers have enlightened us about a lot of topics And telemedicine, especially, I think is the future, and a lot of it is going to come up once AI sets in. So yes, Dr. Karthikeni has given us an idea about how the act works and what all we should do in terms of using telemedicine. So thank you all, and I'd like to thank all the speakers, all the panelists for doing a wonderful job and enlightening us today. Thank you one and all. And thank you, Dr. Rekha, for presiding over the sessions and giving us your inputs. Thank you so much.
Thank you. Thank you.
Thank you, ma'am.